We have both the plaintiff and the defendant, as well as their respective attorneys, Ms. Quist, the attorney for the plaintiff, and Mr. Haskell, the attorney for the defendant. We are here on the plaintiff's motion for a temporary order. Ms. Quist.
Your Honor, my understanding, based on the text between the parties and the receipts that I have seen, is that Mr. Garberick is 95% moved out of the marital home right now. My client has paid for a pod and his move over $6,000 so far. He decided, apparently, and we have talks that he's going to move to their cabin in Land Lakes, Wisconsin. He decided this in November, which makes sense. The monthly mortgage is about $700. It's being paid by my client. She's paying for the electricity and the utilities. Given the conflict in this case, I think that exclusive use of the actual marital home is common sense if Mr. Garberick is moving out, which he has moved out all but a very few small boxes. In regard to spousal support, I didn't respond to their request because there's no budget, there's no guidelines. My client's paying for the cabin in Land O'Lakes, which everybody knows. So she's actually paying for his housing. Mr. Garberick is 47 years old. By their own pleadings, there's a 16-year work history as an applications engineer. I ran the guidelines at his income as an engineer at 70,000 per year on a 20-year marriage. The score's about a 33% out of 100. It recommended an arguable case for alimony due to the income differential, $884 per month. I also ran child support guidelines. I noticed nothing was mentioned about child support. That has Mr. Garberick paying $753 per month to mother. The alimony is $884 per month to father, which is pretty much a wash, but my client is paying for the cabin and Land O'Lakes and the utilities and the electricity. She's also paid for his move and has committed to paying for the rest of the move. His stuff is in a pod right now. So I'm not sure exactly what we're arguing about here.
All right, guys. Today we're stepping into a courtroom where things seem simple on the surface, but quickly feel more complicated. The plaintiff's attorney lays it out like a done deal. The husband has mostly moved out. The wife is paying for everything, even his housing, and financially it almost cancels out. Yet the real hook hits when she questions why they're even arguing. That line sets the tone, because when a case sounds too simple, it usually isn't.
I'm happy to agree that this goes to the friend of the court for custody, parenting time, and child support. If Mr. given the conflict no matter who you believe, given the conflict in this situation, these people should not be in the same house. Each one of them should have exclusive use of the designated place that they've chosen to move. Mr. Garberick has chosen to move to Land O'Lakes. The parties own a cabin there. That makes sense. He has a significant work history and he's 47 years old and she's paying for his housing. I'm really not certain what we're arguing about at this point. I think that it makes sense for it to go to the front of the court. We don't know what happened between these parties. I know that the adult child believes that these things happened and he has stated that they've happened. Well, maybe the friend of the court can sort it out. I know none of us can because we weren't there. But I do believe at this point that Mr. Garberick should continue his move. I think he was told not to move his final stuff out of the house until this hearing. But if he's committed to Land O'Lakes and my client's paid for it and she's paying for the housing, I don't know why he wouldn't just complete that.
Right. Thank you, Mr. Haskell.
Well, we've got not one, but two motions here where they have, for 30 paragraphs, accused my client of being abusive and all these things. And then we come here today and say, we're not sure what we're arguing about. We have a major credibility issue here. We have someone who signed a motion making the allegation that my client spent 90 days in jail when no such thing ever happened, and he was never charged with such a crime. And we have not only that, matters of equity here. Now, the guidelines on child support software for spousal support are not helpful. We have statutory factors or case law factors for a reason. And some of those factors include the length of the marriage and some of the equities involved. And the equities involved here are that the plaintiff made a career decision without consulting her husband or her children, by the way, unilaterally moved across the lake because she was going to make a bunch more money, effectively ending his 16-year career and turning the kids' lives upside down. And now my client's getting blamed for everything that's gone wrong since then. It's not fair. And he is making, if we extrapolate, $2,000 a month approximately with seasonal income. I've attached a case that has gone through matters, and a $10,000 a month income earner and a recipient party earning more than my client got about $3,800 a month. And these things are often ordered by the court. How else is he supposed to pay his attorney fees, rent, and whatnot? As to the house or the cottage, he didn't know where else to go until he talked to an attorney. He didn't realize that he had a choice. That's 9 hours away. It's their cottage. She's not paying for him to live there. They're paying for the cottage. They bought the cottage. It's part of the household expenses. Now, could he live there in the spring? He could. It's not habitable in the winter, which is why the agreement was that he would be coming home for the months during the winter. Does he want to live there? No, it's 9 hours away from his family. And he doesn't even have enough money for gas to go back and forth between these places. She wants to deprive him of the ability to buy groceries, the ability to live anywhere except for this place that's 9 hours away from her. Clearly, we've got a systematic strategy to exclude my client from his family life, from his home life. We don't have any substantiated allegations of abuse. We just have a lot of inference and innuendo, which is frankly uncomfortable.
Here's where everything flips. The defense comes in strong, calling out serious credibility issues and claiming false allegations were made, including a jail story that never happened. Suddenly, this isn't about logistics, it's about trust. He argues the wife made unilateral decisions that upended the family and his career. What felt straightforward now turns into a battle of narratives, with both sides painting completely different realities.
Unconscionable, specifically because it was initially based on an event that never occurred. But it continues to spiral. Whether they've had factual arguments or what have you is not the point. The point is he did not spend 90 days in jail, and all of these things are premised upon this 90-day jail sentence that just didn't happen. So it just continues to spiral out of control. So what we're asking for here is a reasonable temporary spousal support order. Her income is marital property after all, so it's not like he's asking for something that's not his already. And for her to have a status quo order because apparently she's spending the savings or removing it from the account. So we need to have things going into the account during the pendency of this divorce until Ms. Quist and I can come together and work out a settlement, which I'm confident that we can do. And I just think that we need to get my client somewhere where he can live and still take place in his family's life. And we need to address some issues with the minor child. We have a situation where every time my client tries to parent this child, the plaintiff gets more upset with what he notices than the underlying behavior. He sent her pictures of alcohol that the minor child is apparently drinking alone in her room. There were issues with suicidal ideation online. There's been issues with her trading nudes online, which is a crime because she's a minor. There are issues with her sneaking out at 3 a.m. In each of these circumstances, the plaintiff got more upset with my client for noticing the child's behavior than the child's behavior itself. And that's really not something that demonstrates a parent who has an established custodial environment. And so I don't, the other thing that is fatally flawed in this motion is it assumes that the plaintiff has an established custodial environment just because of the temporal allocation between these parties. And I think that's just far from the truth. If you look at who's actually trying to parent this child, I would suggest that the plaintiff does not have an established custodial environment at all because she's not seeking discipline or guidance from her. In fact, she's just aligning with the child to attack my client anytime he tries to address some of this destructive behavior. So what we're hoping for is, as far as child support, the plaintiff didn't ask for it. It's not even before the court. We don't even have a parenting time order. I don't know what the court's going to order with regard to that. I imagine it's going to be a child support issue or FOC issue, and then child support will arise from that. But spousal support needs to happen now so that she can get what she wants and he can move out, because he shouldn't have to move 9 hours away just because they bought a cottage somewhere and that's what she wants. He would greatly prefer to be much closer and to resolve these issues with his daughter
Your Honor,
through
if I may
counseling.
respond.
And
Ms.
we're
Quist.
hoping to get that counseling, and it's another point of argument that we've requested. So I'm sorry, I'm done now.
Okay, Ms. Quist.
Okay, sorry about that. I thought
That's
you were
okay.
done.
I'm sorry, Courtney.
That's okay. That's all right. Your Honor, the events occurred. I blame myself because I sent it DocuSign, and when you send something DocuSign and you read through it, sometimes you miss things. And I think that's what happened, because as soon as I got the response, I called my client. She's like, "No, that's my fault." I'm like, "No, it's my fault. It's my fault." So
Now the case takes a sharp emotional turn. The defense introduces troubling concerns about the minor child, behavior that suggests deeper family instability. But instead of focusing only on that, the argument shifts into parenting blame. Then the plaintiff fires back, admitting some errors, but insisting both parents share responsibility. At this point, it's no longer just legal. It's personal, messy, and layered with conflict that no quick ruling can fully untangle.
did it, which is what you do when you find out that there's a mistake in there. But those events occurred, and they've continued to occur. They also occurred in Wisconsin. So I'm not saying that we know everything that's going on in this house, and I'm not saying this kid doesn't have problems. What we have here is a high conflict situation. My understanding from all of the texts that Mr. Garbrick has sent is that he began packing his things to go to the cabin in mid-November. I have never heard from anyone that he didn't want to do that. And by his own admission in their pleadings, he's gone during the, I guess, non-snow months and comes home once a month. That's not parenting either. I think this kid, the 15-year-old, she probably has some significant issues. I'm not blaming either parent. I think it needs to go to the front of the court for a parenting time assessment. This kid clearly needs counseling, but the fault is with both parents, not just one, both parents here. I'm not disputing that there's an issue, but I'll tell you what, that domestic violence occurred. It absolutely occurred. And of course, we run child support guidelines. We run spousal support guidelines all the time. I don't even have a budget from him. How can I possibly address him asking for $3,500 a month? My client is going to have to pay for the health insurance for this family. She's the only U.S. citizen to be employed by this company. She's been on COBRA for the last 18 months. She has to go on the open marketplace and get health insurance for everybody and pay for it. She's also paying the total freight for this kid and the one who turned 18 and is an adult. They're all living in an Airbnb, which has cost $6,000 since November. So we have his $6,000 in moving expenses, which is what he wanted. We have another $6,000 because of an Airbnb, because he says he's residing at the marital home, and she's going to have to pay for the health insurance. She doesn't dispute any of that. She said the COBRA ran out in November. We have to go in the open marketplace. Nobody is due for any vaccinations, dental checkups, or anything like that, because both parties knew, that the health insurance through Cobra was running out. So everybody went to the doctor, everybody got their teeth checked, and now she's on the open market. So I understand that he feels like he's owed some spousal support, and maybe he is, but at this point, she's got to find health insurance for these kids. She's paying the 100% freight for the 15-year-old, and they've been in an Airbnb for 2 months. Um, this is the first time Mr. Garberick has said anything that he doesn't want to go to that cabin because I have texts, there's records, we have receipts where that's where he decided to move. So today is the first day, because if you'll notice in their pleadings, they state that he doesn't have housing. Well, that was a surprise to me because she's paying for him to move there. If that's not the case, then what is the real case? Because I don't know. But at this point, we're asking that he move to the cabin on a temporary basis, that she continued to pay for the cabin, she can't pay for everything. He has a 16-year work history. He's 47 years old. He has he had a career as a material engineer. I mean, what are we talking about here? He needs to just get back to work on a regular job and not just on a seasonal job. All of us need to work full-time year-round. So I'd ask that this go to the front of the court for, I believe, a custody, parenting time, and child support assessment. I'm 100% on board with counseling. Absolutely. I think it's important here, and I don't know what's going on with this kid. It doesn't sound great by everybody's admissions. I don't think it's as bad as Mr. Garbrick makes it out to be. But I do believe there are some issues here.
All right, thank you. The court,
Briefly, Your Honor.
no, you don't get another rebuttal or
Oh,
a
come on.
rebuttal. No.
Okay.
But then
All
I'll
right.
rebut the rebuttal. That's
I
why.
know, yeah.
It won't be here all
That's what we're
morning.
doing on
No,
the
no, no.
papers.
No, I will grant joint legal custody to the parties of the minor child. I will also grant sole physical custody on a temporary basis to the plaintiff because it sounds like that's essentially been the status quo for a while. Until we get to the bottom of what's going on with both his child and all these allegations that are flying around, I will grant supervised parenting time to the defendant. And order that this child go for counseling, attend counseling as recommended by the therapist, and that can be individual counseling, substance abuse counseling, whatever that therapist recommends. And I would expect that both parents cooperate with that.
I'm open to suggestions for counseling. It's hard to get people in. It's hard to find out who is currently taking.
It is, and I
Yeah.
can certainly take judicial notice based on my juvenile docket that it's very difficult to find counselors for children.
Mike and I could probably put our heads together and try and figure out who's currently taking.
Yeah,
Clients.
with regard to that, can I just suggest that either one of us provide the other with a list of three? I want to make sure that this counselor never sees this courtroom, that the counselor is for the child and that we're not.
I agree. I agree 100%.
I agree.
So if we can just find someone that's maybe not on your normal docket, I don't want a litigation counselor. I want someone that's going to help. So if Courtney and I can agree on that, then
Sure.
I don't care who sends the three names. I can do it. She can do it. I don't want them to be the names that we see every day.
Hey, Mike, let's try and figure out who's taking clients too, because I don't want us to exchange names and then both you and I find out that none of them are taking clients
And
right now.
I've
'cause they're so
had
busy.
I've had that happen. So I would
Yeah.
ask
And
that
then
both of
and
you.
maybe we can do a little collaborative light and have a joint conference call.
Sure,
And
that's
so
fine.
that we're not doing this advocacy thing with the child. The other question I have, the supervised parenting time, I mean, I guess well, I'm not going to continue arguing, but can we do something like with the Gabriels or something instead of Journeys with this
Sure.
16-year-old?
Absolutely. That's no problem.
Okay,
Mike, why don't we
thank you.
talk after this? We'll do something like that.
Okay. Oh, you weren't done, Your Honor. I'm sorry. Um,
No, I wasn't.
Sorry about that.
All right. I was pausing to gather my thoughts.
Taking a
I will,
breath.
yes,
Yeah.
I will grant the plaintiff's request for exclusive use of the marital home regarding child support and spousal support. I will order that there be a status quo order regarding finances. But that in addition, on a temporary basis, that the plaintiff pay $500 in addition per month spousal support. And that can certainly be amended at any time, as well as dealt with in the final judgment. Just to get this case moving along. And was there anything else?
My client is getting health insurance. She just has to find some that's through the open
Does that
marketplace.
include me?
Yeah, it would-
Yes, during the pendency of that,
yes.
that would include, yes.
He has prescriptions that need filled. We had a request for attorney's fees for the second response that we had to draft, which I think is reasonable in the circumstances. The exclusive use, can we get a timeline on that? If.
Well,
frankly,
what is your suggestion?
Well, a few weeks, but I think with this $500 thing, I don't think he's gonna have any choice but to go unless the status quo order allows him continued access to the income and the account, he can get a lease that way. He's gonna have to go 9 hours away, which is gonna cause problems down the road for him. And I'm just trying to keep everybody close and see if we can heal this family a little bit, but I don't know how he's gonna do it on $500 a month. I understand
You're
the
my-
council's
my client-
argument that he should get a job, and I don't necessarily disagree, but the reality is the situation right now, in the next 3 months, we have to deal with.
Your Honor, my client's paying for the cabin in its entirety, and maybe they'll sell the cabin in the end. But she's,
I've made my decision on it,
Okay,
so
all right,
whatever
thank you.
happens has to happen, because I feel like with the moving expenses and the payment of the cabin, as well as the utilities, et cetera, that should give sufficient.
2 or 3 weeks. Oh, I can't hear you.
Oh yeah, Judge, your sound went out.
I lost audio at some point and we had to take a recess. My understanding is the parties used the time wisely, and I don't know if you want to put a summary on the record, and then move on to the one issue that was still sort of hanging out there, which is the attorney fees request.
Would you like to do it, or you want me to, Courtney?
Yeah, we've made various agreements based on your rulings, joint legal custody to the parties. Ms. Garbrick has sole physical custody on a temporary basis. Mr. Garbrick will have supervised parenting time. We've agreed that it will be an informal supervisor, possibly the Gabriels. We've agreed that the attorneys will come up with 3 names for therapists that are not usually in the litigation setting. Mr. Haskell and I can certainly talk and try and figure out who's actually taking clients at this time because they're busy. Ms. Garbrick will have exclusive use of the marital home. Mr. Garbrick has indicated that he is moving out this weekend. There will be a financial status quo and a general prohibition on anybody destroying, changing, secreting, all of the prohibitions, each other's personal property. Everything is to remain untouched. Ms. Garbrick will pay on a temporary basis $500 per month in spousal support. My client, Ms. Garbrick, is looking for health insurance on the open market. We do not know what that's going to cost yet for this family. And Margaret Allen will be the mediator in this case. And this will go to, the matter will go to the friend of the court for custody, parenting time, and child support. In regard to the attorney fees, I don't believe that they are justified. When I look at their amended response, which I only amended one thing, which was an error, that event occurred. It absolutely occurred. And honestly, because of that situation, I don't believe it's justified. I think I have a duty to amend pleadings if they're in error. I look at these pleadings and I notice it says he does not have any housing, when that's frankly not true, which is why I was confused when I read their response saying he doesn't have access to housing when he made the decision in mid-November to move to the cabin. Today is the first that I've heard that he doesn't want to move there. He's the one who wanted to purchase it in the first place. So I disagree. I understand and acknowledge that there was an error for my client not reading the DocuSign. I corrected it and adjourned the motion, which is an appropriate thing to do. But I don't agree that attorney fees should be granted either way. Also, in regard to attorney fees, if it's just a general request, at this time, we're status quo and he's receiving spousal support, he's receiving housing. He can certainly work full-time. He's 47 years old, and he has a significant work history. I predict that he will be able to easily find a job. It looks like he had a great job before. So I disagree with attorney fees at this time. Of course, the issue, Judge, could be reserved for the final property allocation, which it could be reserved for both parties.
Mr. Haskell?
Well, we're going backwards here, but that's okay. We have a verified pleading where an allegation was completely invented and it was trickled throughout the pleading.
No.
And she signed it. You know, he did not spend 90 days in jail regardless of whatever happened. It was false. They amended the pleading unilaterally and postponed the hearing unilaterally, even though we'd already responded. And it wasn't just that. There were other things as well. They added an affidavit. They added, a number of other things to try to restore her credibility.
This is where the judge steps in to bring order to the chaos. Decisions come one after another: custody arrangements, supervised parenting time, mandatory counseling, and financial rulings. Neither side gets everything they want, but both are held accountable. The final moment lands with attorney fees granted, reinforcing that actions in court have consequences. It's a controlled ending to a volatile situation, but clearly not the final chapter for this family. Make sure to like the video, subscribe to the channel, and we'll see you in the next video.
And we had to play this game where we figure out what is actually a new allegation and what's not a new allegation, all just so that we could address Ms. Garbarik's attempt to rehabilitate her credibility. And that's, if attorney's fees aren't merited for that, I don't know what is. And what's the purpose of a verified motion? And frankly, you don't even need to go to the behavior of it. We have a situation here where he has a need and she has ability to pay. So you can grant attorney's fees simply on that prong, which what we request that you do. And if you're going to do that, you may as well give him enough to get through the mediation, because he's going to have to pay for an attorney to get through this. And it's marital property anyway. So it's just a pragmatic issue at this point. We need it.
All right. I will grant attorney's fees, but based on the part of the court rule that addresses need and ability to pay, I will grant the $1,925 requested.
Okay, by when, Your Honor?
2 weeks.
Thank you.
And is there anything else?
No.
No, I don't think so.
All right, thank you. We're adjourned.